are days in which I shake my head and just wonder if the world has gone collectively mad. And I wonder that because announcements are made that nobody seems to react to, when I'd expect the reaction to be either one of derision or you are joking or even dissent. But we seem to have accepted today, and if I was going to make a comment about modern times in 2024, that when something seems absurd, we are scared to in actual fact say it is for fear of being branded somethingist. You know what I mean? Well, cue the latest case of the Supreme Court of New Zealand. A relatively odd institution. There was a great deal of debate in actual fact when it was formed as to whether or not it should actually, if we had the intellectual or prudential grunt to be able to support it. And there was thoughts that we should, make the High Court of Australia ours or just leave it with the Privy Council in Britain. But nevertheless, we've got one. And one might argue that the Supreme Court, and prior to it the Court of Appeal, have become activist in our lifetimes. They haven't simply interpreted the law, they've actually made it, which is something that I have to say pisses politicians off to a large extent, and it certainly has upset David Seymour and the ACT Party, which is why they've raised this whole concept of the Treaty Principles Bill, rather than let activist jurists do that for them. And I have to say, as somebody who's studied law, but also as somebody who's been in politics, it's surely the democratic will of the people is best expressed through, obviously, the House of Representatives. That's the political organisation. These are the people that create the law. At the end of the day, you expect the law courts to administer the law. You don't expect them to make it. But over the last, 20, 30 years, and I go back to 1987, New Zealand jurists have decided that they quite like to be active and they quite like to create. And if there is any ambiguity, boy, they like to drive a bus through it. One might well argue that that's what's happened with this next case. Maori activist and radical and tree tropper Mike Smith brought a case which was dismissed by the lower courts, arguing essentially that 7 major corporates were committing, a form of genocide, basically, and that they should be required, in large part, to, if not cease their operations, then certainly by a certain time, desist from polluting the environment and particularly the airspace, so that Maori people could live and not die early. I mean, I know I'm sort of truncating the case a little, but it's not that much more sophisticated. One person who has certainly shares similar views and is concerned about where this is all going is New Zealand Initiative potentate, and also, it has to be said, a very smart commentator on matters political, has columns published frequently, I say, in The Australian, which I read often, and that is Oliver Hartwich from the New Zealand Initiative, and he joins us now. Dr Hartwich, love to have you on again. Thank you very much for coming on.
Good morning, Michael.
Take me through the case. I've given a sort of, you've just heard the summary of it. Is it more sophisticated than that?
No, I mean, you summarized it really well. I think the one thing we have to say, though, before we get into the discussion, we have to be careful with what we say, because this case is still before the courts, and as a lawyer yourself, you would know that you have to be careful not to fall into contempt of court. So whatever we say, we should probably begin with a statement that whatever we say, we have the greatest, the utmost respect for the Supreme Court, and still, I've got a few question marks about this case.
Can I say I've got no respect for the Supreme Court, haven't had for a long time, never will. I think they're a bunch of activist jurists. I don't think they're very bright either. So if they hold me in contempt, we have to be careful
when we discuss these matters, because otherwise you find yourself in trouble.
Good luck. I'd invite them to hold me in contempt of court for that. Now, I know you're being facetious. So, Oliver, seriously, the plaintiff is an elder, he is now, of the Ngāpuhi and Ngāti Kahu iwi. And he has been a climate change spokesperson for the iwi Chairs Forum, which is a sort of conglomerate of all the iwi in this country. Their chairs go to it regularly. He brought proceedings against 7 of New Zealand's largest companies in 2019, claiming an injunction to stop them from contributing materially to climate change. And the 7 include household names like Fonterra, Genesis Energy, New Zealand Steel, Z Energy, just being 4 of them. He says that the defendants have materially contributed to the climate crisis, and he says, quote unquote, in this claim, they have damaged and will continue to damage his whenua and moana, including places of customary, cultural, historical, nutritional and spiritual significance to him and his whānau. Can you explain to me why the Supreme Court is actually listening to this gibberish?
Well, this is what Mike Smith did. So he took his claim to the High Court as the first instance and argued that he was harmed in his rights. And he used what lawyers like us know as tort law. So tort law is the law developed under the common law where you claim that you have been hurt through the unlawful actions of somebody else. It's a civil proceeding, basically. It's not criminal law. So you have to claim that there was a damage caused to you by somebody else in an unlawful way. And the common law over the centuries, really, has developed some torts out of this basic principle that he is now applying to that. So he claimed that there was an element of public nuisance. So the typical public nuisance case is where you have a factory, the factory pollutes the environment, and the neighbors suffer damage, and therefore you take the owners of the factory to court to get redress. So he claims that's what's happened. He also claims that there is an element of negligence involved. So that's where you are not careful enough in your actions and you're causing harm, damage to somebody else through this act of negligence. And then he claimed that there is an altogether new tort, which has never been tried before, and that is damage to the climate system. So that's something that he suggests the court should now decide exists. So he can actually claim that these defendants were doing something unlawful, and in that way they were damaging the climate system. Now, what happened in the High Court was that the High Court actually struck out the first 2 torts and says, actually, no, there is no public nuisance, there's no negligence involved, because the link that you draw between these 7 polluters and the alleged harm that you say you suffered is very remote and not direct. And I mean, once you started studying tort law, you know you need to prove that there is a direct causal relationship between your actions and the harm you cause. And the High Court basically said, look, it's just not there. The third tort, this alleged climate damage tort, well, the High Court wasn't so sure about it and allowed an appeal. And so it basically went to the Court of Appeal. And what happened there was actually the Court of Appeal struck out the whole case, saying, well, actually, there is none. There is not nuisance, there is not there's not negligence, and you don't have a climate change tort. And then what happened was that the Supreme Court allowed an appeal. I mean, the Supreme Court doesn't have to do that. It basically invited Mike Smith to present his case in the highest court of the land. And there we got the decision last week. The Supreme Court decided that it was totally legitimate for Mike Smith to bring that case on all 3 alleged torts, and now the whole thing will go back to the High Court. Now we should be clear about this. The Supreme Court has not said that actually there is a tort. It only says there might be a tort. So the whole thing goes back to the High Court, from where it will probably end up in the Court of Appeal again, and probably at some stage also in the Supreme Court. So the whole thing will probably drag for years, I would say at least 6-7 years, before we might eventually get a final ruling from the Supreme Court, because there's only one certainty: whoever loses in the first instance will take it to the Court of Appeal, and eventually, because it is such a novel thing, the Supreme Court will have to decide. And now we can go through all the reasons why I think the decision actually we got might have been a little bit misguided, shall we?
Yeah, sure. Just before you carry on, though, I am interested in the idea, though, that there was such a definitive ruling from the High Court and particularly the Court of Appeal on this issue. Who has to grant the leave for it to go to the Supreme Court, or is it automatic, Oliver?
It is not automatic. It is the Supreme Court itself the Supreme Court can decide which cases it wants to hear, and this was one of them. So the Supreme Court invited Mike Smith. It didn't have to. There was no automatism. The Supreme Court could have said, okay, Court of Appeal, happy with your ruling, and we are not going to look into this. It stands. But they didn't. They invited Mike Smith to take the court to the Supreme Court, and that's where we got a ruling. And by the way, this took us 2 years. So the invitation for Mike Smith to present to the Supreme Court was made a couple of years ago, and it took that long to come to that ruling that we got last week.
The thing that staggers me, and I've read the Supreme Court, the hearing was, in actual fact, in 2022. There were further submissions in that year. So, I mean, it's taken an awful long time for this to come out. It was only published, earlier this month, Oliver. So it's taken them, God, how long is that? It's taken them almost a year and a half to get the judgment out.
As far as I can see, the whole case actually goes back 4 years once you include the High Court and the Court of Appeal. So this whole thing has been dragging through our court system for 4 years, and I predict it will probably take even longer now to actually start the whole process again from the High Court to the Court of Appeal to eventually the Supreme Court. So I think we can probably expect the next 6-7 years to be dealing with this case.
But the other thing that interests me is there's almost a page of counsel just listing the names of the people that are involved in this. I think most of the seven defendants. I'll just go through them. Fonterra Genesis, Dairy Holdings Limited, New Zealand Steel Limited, Z Energy Limited, Channel Infrastructure New Zealand Limited, God knows who they are, and BT Mining Limited. Well, they've all got lawyers. But then so is Mr. Smith. And then so the Maori Law Society have said, we want to be involved as well. And so is the Human Rights Commission, for God's sake. So they've attached themselves to it as well, the latter paid for by the New Zealand taxpayer.
And there is another pressure group involved, and that's Lawyers for Climate Justice. They were also supporting with this case.
Yep.
Yeah. So it is a massive legal undertaking, and you can already see by just listing all the various defendants and parties involved, this will cost millions in legal fees over the next few years until they get to the
Absolutely.